unsafe practices which reduce competition or fix prices for services. I think
Which chapter is that again? I'm sorry.
it's the Licensing Act. It's
Okay.
I don't know what section number it is. It's in Larry's materials.
Okay.
If you want to go back and look at Larry's materials, you can go read those 50
No,
pages.
thank you.
Okay.
General
Protect the general public from unsafe practices which reduce competition or fix prices for services. All right, so in the mortgage loan, which document establishes the debt? The note of the mortgage.
Nope.
Okay. All right. When I ask you questions about essential elements of a contract, I don't want you to overthink the question, okay? Essential elements of a contract are essential elements, essential elements in an agreement of sale are essential elements of any real estate contract. What are those essential basic elements that you need? Well, first of all, competent parties. The second thing is offer and acceptance. Now, I'm going to tell you this again. Mutual assent is offer and acceptance. And Dave, in years past, has listed that as an element of a contract. And some people, that's the first, which of the following is not an essential element of contract? And everybody circles mutual assent. No, mutual assent is offer and acceptance. It is an essential element of the contract. It's just another word that refers to offer and acceptance. So know that mutual assent equals offer and acceptance, that element of the contract. Hint, because that's on my exam too, okay? All right, what is another essential element of a contract? It's got to be supported by consideration. So, competent parties, offer and acceptance, sometimes called mutual assent, consideration. Then what else? Objective. The objective of the contract has to be legal, legal purpose, okay? The final thing is there's got to be voluntariness, what the book calls consent. Now, a contract that's entered into lacking the consent makes that contract voidable. So when a contract lacks the element of consent, and that's the only element it's lacking, then it makes the contract voidable. If a contract is lacking any of the other essential elements, it renders the contract void in most states. All right, now, things that are not essential. Do people pay cash for property?
Yes.
So is a financing contingency essential?
No.
People buy property as is. Is a home inspection contingency essential?
No.
Okay. All right, in Delaware, the realty transfer tax is customarily paid by who?
Both parties.
And what's the split? But what is the split between the parties? No, that's the transfer tax.
50-50?
It's half by buyer, half by seller.
What was that term? When did you start this? I was
The real estate transfer tax is customarily split between the buyer and seller. Each is paying a half of that. Now, you were right. Each is going to pay 1.5%. The total transfer tax collectively is 3%. Okay. Life estates are generally created in wills. So if there was a will that says, I give, when I die, you get this property for the rest of your life, and then it will go to your children. So in that situation, that party, when that person dies, has a life estate. The children are what are they called?
Remainder.
They're called remaindermen. So let's do a deed example. Roger Granson conveys to Donna for life and then to Donna's children. Donna's got a life estate. The children are remaindermen. Okay? All right, with tenants by the entireties, there is this right of survivorship. So when one spouse dies, the other one becomes the owner of the property. It will pass to that spouse by virtue of that right of survivorship that is part of tenants by the entireties. Okay. The last class, we went through a laundry list of who pays what on the settlement statement. So the loan fees, who pays for that on the settlement statement? The buyer pays for that. Those are his. The appraisal, the lender charges. Who's going to pay for that?
The buyer.
All right. The lender doesn't trust the taxes to be paid, so they have the buyer escrow, and they pre-fund the escrow account. The pre-funding of the escrow account, who pays for that? The buyer does. The buyer does that.
Yeah, that's right.
It's the escrow account for the loan, so that loan is the buyer's loan. So those monies that are prepaid in escrow are on the settlement statement are buyer charges. The title stuff, the title search, the title examination, the title insurance policy. Who pays for that? The buyer. The real estate commission, who pays that?
Seller.
Seller pays that. Okay. The statute of frauds requires an agreement of sale to be in writing. It requires both the offer and acceptance to be in writing. So when an agreement of sale is being presented, if it's being presented verbally, and then the seller verbally accepts the offer, and we're talking about an agreement, we're talking about a verbal agreement of sale involving real estate, do we have an agreement? All we've got is what? We don't even have an offer because it's not in writing. So in order for there to be an offer, it has to be in writing because of the statute of frauds, and acceptance of the offer has to be in writing. If the parties are just verbally discussing it, what is that called?
Negotiation.
Negotiation. Okay, in Unit 2, we talked about the ability of a party to transfer the air rights, surface rights, but reserve to himself subsurface rights if he wanted to. We did that in Texas, so, you know, farmers like, I just found a crap ton of oil underneath my farm. All right, well, I'm not going to be a rancher anymore. I'll sell the ranch. You can keep the surface stuff and have cows running all over the place if you want. Get the air rights too, but I'm going to reserve to my rights the oil in the ground, and I'll also create an easement so I can come on the property and pump that crap out of it because it's mine. So you can independently transfer the air, surface, and subsurface rights. And if you haven't transferred the subsurface rights or the oil rights, then you get to keep them. The rancher gets to keep them. Okay. In Unit 4, when we were talking about interest in real estate, we talked about statutorily and common law imposed life estates. So one of them we talked about was dower and courtesy. Dower and courtesy was the rights that the common law gave to a surviving spouse in their deceased spouse's property. So what it would say is if you were in a dower and courtesy state and one spouse just owned this particular real estate, and when he died, he left everything to his little chippy on the side, the surviving spouse would get a life estate. That's dower and courtesy. So that's a legally imposed life estate based on common law principles, which the idea was we don't want to permit you to disinherit your spouse. We'll give them a life estate. Now, don't get that messed up with co-ownership. If they co-owned it as husband and wife, then let's say they co-owned it as tenants by the entireties, and he left everything to his chippy. Well, again, that might be why he's dead too, right? God forbid you do that to Mrs. Cepeda, you'd definitely be dead. She scares me a little bit. Okay. I'm kidding. She's a delightful lady, okay? All right. So, if they co-owned it as tenants by the entireties and he leaves everything to his, chippy on the side, when he dies, the wife owns it because of the right of survivorship. So what we're talking about with dower and courtesy is when the property is just owned by the spouse and the other spouse is disinherited, dower and courtesy would allow for them to get a life estate, okay? And then the other one we had was homestead. Homestead was this kind of life estate that allows you to protect the family residence from creditors. So long as there are surviving members of the immediate family using the residence as a residence, then the creditors are not allowed to come after and force the sale of the property. Again, the example was O.J. Simpson. The Goldmans sued him, got $30 million judgment. They couldn't touch O.J.'s mansion because it was a residence. And because of Florida's homestead law, it protected it so long as it's being used as O.J.'s residence. All right. Okay, the Real Estate Commission has a lot of power, but some of the things they really don't do is when they discipline you, it's nothing deemed criminal. It's administrative. You know, they can suspend, revoke your license, they can fine you, but none of that's considered criminal. And part of the reason why this question's in there is one of the powers it gives if you read it carefully and specifically, it says they have the power to prosecute violations of the act and rules and regulations. And so they use I don't know where it is in the book, but that word is used. And so years past, Dave would latch on to that, and someone would hear prosecute and think, well, that's criminal, so they can come after you criminally. No, the word prosecute just means that they can enforce that against you, okay? So they can't do anything criminal. They could call the Attorney General's office and say, hey, we're disciplining this dude because he ripped off money from his clients, and you might want to investigate and maybe pursue a criminal theft action against them. But whatever you're doing to them is considered administrative. The other thing is the commission is not a trade association. They don't solicit business for the real estate industry. They're there to protect the public primarily from unsafe practices which reduce competition or fix prices for services. And I'm such a loser for knowing that on the top of my head. Okay. All right. They don't have the power to put you in prison, okay? They can't do anything criminal against you. All right. In Unit 5, we talked about forms of real estate ownership. And one of those was a condominium. And with a condominium form of ownership, you own your unit in fee simple absolute title. So you own actually the space in your unit in fee simple absolute title. And then the common elements, you have some specified percentage interest in those common elements. That means you co-own the common elements with the other condo owners. This isn't on the final, but it possibly is on the state exam. The form of co-ownership is tenants in common. You own as tenants in common the common elements with the other condo owners. If you have trouble remembering that, just remember with tenants in common, you can have differing fractional interests. With condominiums, your percentage interest differs from the others based on relative size. So because you got differing fractional interests, that has to be tenants in common. That's another difference between tenants in common and joint tenancy is the fractional interest. With joint tenancy, they cannot be different. They have to be equal. With tenants in common, they can be different. So with tenants in common, you can have a 1/4, 1/4, 1/2 form of co-ownership. But with tenants in common, those three owners would have to be 1/3, 1/3, 1/3. Okay? So joint tenants can't have differing fractional interests. Tenants in common, you can. All right, again, with easement questions, if someone is given the right to cross another person's land, draw it out. The parcel where the physical easement lies is the burden parcel. It's called the servient tenement. The parcel that benefits, it has the right to cross over, is the dominant tenement. It benefits from the easement. The burdens and benefits run with the land. Successive purchasers will take subject to the burdens or benefits. Okay. In the Licensing Act, we talked about psychologically impacted properties. And I'm not going to ask you anything other than knowing what a psychologically impacted property could be under the code. I think it's section 2929 of the Act. I think that's it. The first category of a psychologically impacted property was the property is the site of a homicide, suicide, or other felony except arson. Now, arson's not deemed a psychological impact. Why? Because arson is physical. It's more than psychological. So when someone gets murdered in a house, what physical damage is being done to the home? Maybe a bullet hole or here or there, okay? But that's deemed psychological impact. You hang yourself in the bathroom, okay? You might have damaged the curtain rod there, the shower curtain rod, right? But it's predominantly psychological, right? There's very little, if any, that does any material damage to the property. The reason arson is not considered a psychological impact is you friggin' burn the place, okay? That's about as physical as it gets, okay? That's why arson is not a psychological impact. It is specifically exempted. It's something you absolutely must disclose as a seller. Again, that first level of psychological impact, the seller's not required to disclose those things unless the seller asks in writing. I'm sorry, the buyer asks in writing. All right, but I'm not going to ask you to know that. Okay, that might be something on the state exam, but it's not going to be on my exam. All right, what's the other psychological impact? The occupant tested positive for HIV. The occupant is infected with AIDS. You ought to Google YouTube and Google the commercial for the weight loss product AIDS, and just listen to that commercial. It's sort of hard to laugh about that, but you should get AIDS because AIDS will help you lose weight, and AIDS is this and that. It's like, oh my God, that's so horrible. That's why they had that product went out of business because of they called it AIDS, and then about 3 months later, autoimmune deficiency disease, better known as AIDS, comes out, and they're like, oh shit, well, damn, that's some shitty luck right there, right? You guys remember AIDS, the weight loss product, right? Those of you who are older, and the young people are like, what the hell's he talking about? All right.
How about the airplane noise?
Iris, we're reviewing for the final. So we'll talk about airplane noise. You asked me after class, so we'll talk about airplane noise and stuff. Okay. All right. Now, if I have fee simple absolute title to the property, I have the right to own it and possess it right away, right? I own it, I can live there, right? I have a leasehold. I'm a tenant under a lease. I have the right to possess it right away, right? I have a life estate. Roger Granson conveys unto Donna for life. Donna gets to possess that property right away, okay, for her life, okay? All right, that life estate situation. Roger Granson conveys to Donna for life. What am I? Roger, I have a reversionary interest. Do I have the right to possess the property when I convey it to Donna for life? Donna's not dead. No. I have a future right to possess, but not a present right to possess. Okay, Roger Granson conveys to Donna for life and then to Donna's children. What interest do I have? None. What interest does Donna's children have? Their remainderment. Do they have a right to possess the property by virtue of their remainderment right?
Yes.
No,
Oh,
they don't. They are remainderment. They would get to own and possess it upon Donna's death, but until Donna dies, they are just remaindermen with a future right to possess. Now,
Sorry.
Donna's not going to kick her kids out of the house.
Well, I
Unless,
thought you said Donna died.
we didn't kill Donna yet.
Sorry.
Donna's still alive.
That's a good thing.
Yes, yes.
How old are your children, Donna?
31 and 27.
Okay, they're not in her house, okay?
No.
They're remaindermen. So their right of possession clearly is not till Donna passes, okay? So you're given a list of different interests. You have to identify which one is a present right to possess and which one is a future right to possess. All right, present possessory rights would be fee simple absolute. A life estate, so long as you're alive. A leasehold estate, yes, the tenant has a right of possession. Future rights to possess would be reversionary interests, remainderment interests. Remember the defeasible estates? So you violate my condition of ownership, so I've got a right of reentry or a possibility of reverter. All of those mean I have a future right to possess if you violate the limitation or condition, okay? So you get a list, you got to figure out which one is future rights to possess, which ones are current possessory rights, okay? Believe it or not, in law school, there was an entire semester of future interest property law. Now, I was very interested in property law, but not that interested, okay? And those unfortunate souls who took that, they got to a point where they actually were bringing in reading material. That's how boring it was. So they would bring in the paper, and they would sit there and read the paper, so they would get count as being present, but they weren't present because they couldn't stand it. They wanted to blow their brains out. Okay. All right. Okay, in the contracts unit, which was unit 12, we talked about a liquidated damage clause. And if an agreement has a liquidated damage clause, it's got a clause in it where the parties have agreed upon and predetermined what the damages are. So I might have said this years and years ago, I have no idea, but I tended to date hairstylists, and they would have their employment agreements. A salon that would hire a hairstylist would have you sign an employment agreement, and a lot of these ladies had aspirations of having their own salons at some point. So they were wondering what this employment agreement would do and affect their ability to open up a salon. I would look and I'd be like, it's got a non-compete, but it doesn't have a liquidated damage clause. So if you want to violate the non-compete and open up a salon, right next door the day after they terminate you, they can't really prove damages because they don't have a liquidated damage clause. So then, years later, the salons were getting a little better and understanding that they had a hard time enforcing non-competes because they couldn't prove damages. So the agreement would have a clause in it that says, if you violate the non-compete, we agree that my damages are $10,000. So then I'm looking at it, I'm like, okay, well, if you violate the non-compete, which says you can't have a salon within 5 miles 1 year after the agreement's terminated. So if you open up one within 5 miles, they can sue you, and all I got to do is show that you located within 5 miles within a year. That's all I got to prove, and that's easy. Because they don't have to prove damages because you agreed to them. So a liquidated damage clause is a clause in agreement where the parties predetermine the amount of the damages. It's a clause where they have agreed upon and predetermined in the agreement the amount of damages. That means they don't have to prove them. They're agreed upon, right? Everybody understand that?
Yes.
Yes.
Okay. All right. Again, mechanics liens. Only parties who furnish labor or material for the benefit of a structure. That is, they're repairing it, doing some level of maintenance, they're constructing it. Those are those activities where you're supplying labor and material for those kinds of activities. Those people are the only ones that can file a mechanics lien. All right, Unit 6, we talked about legal descriptions. And in Unit 6, the 3 methods of describing property were meets and bounds, the rectangular survey system, sometimes referred to as the government survey system, and the lot and block system. So meets and bounds are courses and distances. It's a description that says you start at this point and go out at this angle. That's your course. You go from that one point at that angle to this point, 20 feet away. So there's your distance. So your course and distance. From that point, you go at another angle, a certain course, a certain number of feet, there's your distance, to another point. From that point, you go another course, and again, an angle, a certain number of feet to another point, there's your distance, and then from that point back to the point of beginning. Courses and distances, meets and bounds, okay? The rectangular survey system or government survey system relies upon government survey maps. You're referencing information that points you to an area on a map, a government survey map. The lot and block system relies upon recorded subdivision plats or plans or plots, depending upon what county you are in the state of Delaware. Plots, plans, and plats, right? So subdivisions, recorded subdivisions, that's what the lot and block is. It's nothing more than a reference to the lot, which is the specific parcel, shown on the block, which is the subdivision. So a lot and block description might be, you are parcel 29 in the recorded subdivision of the reserve at Hocus and Chase in microfilm number 15729. So it references you the block, which is the subdivision, and it references you the lot, which is the particular parcel, okay? All right. A general lien. A judgment is a general lien, okay? Specific liens are liens like mortgages and real estate taxes.
Could you repeat that? I'm sorry.
All right, there's two ways of categorizing liens. You can categorize them as specific versus general, and voluntary versus involuntary. A general lien is a lien that attaches to all property located in the county in which that general lien is recorded. A judgment is a general lien. If you've got a judgment lien, it means that you've got a lien against all the real estate that I own in that county. So if someone sues me and they win and I own 5 properties in Newcastle County, that judgment is a lien on 5 properties. It generally applies to all the things I have. The specific lien is specific to a particular parcel. A mortgage is a specific lien. Real estate property taxes are a specific lien. Mechanics lien, it's specific to the property you worked on. It's a specific lien. Okay, a mortgage, is it voluntary or involuntary?
Volunteer.
Real estate taxes, voluntary or involuntary?
Involuntary.
A judgment, involuntary or voluntary?
Involuntary.
Okay, we know that. All right. Now, priority. The basic rule of priority is first in time, first in right. But we know that property taxes are that special exception. And they have what's called super priority. That means that they take priority over all prior recorded liens. Super priority. Okay, I'm a buyer, or I'm a seller, and the buyer has refused to buy the property. 300 years later, I decide to sue the buyer. Is that case going to move forward, and if not,
No.
why?
Statute of limitations.
Statute of limitations. Okay. Okay.
Which is 18 months, right?
It's 3 years for breach of contract.
Oh, 3 years.
Personal injury is 2 years. Okay. In Unit 7, we talk about transfers of title, and we talk about these different types of deeds. And the first 4 deeds that were listed in Unit 7 in hierarchy of the level of warranties, starting with the one with the highest level of warranties to the one with the lowest level of warranties. So at the top of the list is a general warranty deed. That's the one that provides the most level of warranties. Now, what do we mean by warranties? It is the grantor warranting against title defects. That's what we're talking about. They're saying, I'm guaranteeing that there's no title defects. That's what the warranty is. The special warranty deed was the next in line. And then the next one was bargain and sale. And then the final one with the least amount of warranties was the quit claim deed. Okay, so general warranty, special warranty, bargain and sale, quit claim. Those were the 4 types of deeds based on warranties. Okay, the general warranty deed, what are you doing? You're granting warranties against title defects that occurred not only during your period of ownership, but all prior periods. The special warranty deed, you are granting warranties against title defects that only occurred during your period of ownership and no prior periods. So special warranty is limited to the period of time they own the property. It applies only to his period of ownership. The bargain and sale deed, there is no expressed warranties, but there is an implied warranty. What is the implied warranty? The warranty implied in a bargain and sale deed is the grantor is actually the owner. I'm not giving you any other warranties, but I'm implying that I'm at least the owner. There won't be a title defect related to whether or not I actually own. Okay? The final one is the quit claim deed. That deed, there is no express, no implied, no warranties, none whatsoever. None. Now, again, people might be thinking, well, what good is that? Your seller is not even saying they're the owner, because they're not. They're not even warranting you that. They're not giving you anything. They're saying whatever I own, whatever interest I may have, may be absolutely nothing. I may have no interest at all. But whatever it is, it's yours. And it may be nothing. Okay? Now, why would we even use a deed like that? Because we use them to cure what's called a cloud on title. You use a quit claim deed to cure a cloud on title. Dude, I did my title search, and it came back showing that you were one of the list of heirs. And you did not renounce as an heir, but you didn't sign the deed. Why didn't you sign the deed? Well, I was adopted, and so I should not have been a part of the estate, and I had no interest. Well, that may be what you feel, but here's what I think the law says. Because you're adopted, you are deemed a blood child of this particular person who adopted you, as if you were born from them. So you are a child. No, I'm not. I was adopted. Okay, fine. I do need you to sign over your interest because we've got some discrepancy. You think how you think. I'm pretty sure I'm right. You are pretty sure you're right, although you're wrong, but you're right. Okay? So I need you to deed your interest. Well, I'm not signing anything where I'm suggesting I have an interest in property. Well, guess what, dude? We got this wonderful deed called a quit claim deed. You're not giving me a warranty. You're not even telling me you're the owner. You're saying whatever interest I have, whatever it may be, and it could be nothing, it's yours. Oh, hell, I'll sign that. Guess what? He cures my cloud on title, and he doesn't expose himself to liability. That's what you use a quit claim deed for, fixing those kinds of issues. Okay? All right. Okay. Earnest money deposit. So we have an agreement. We don't have an agreement. The buyer has made an offer, and he has put up $1,500 as a deposit, and he's agreeing to pay $150,000 for the $150,000 for the property. So he puts up $1,500 deposit, makes an offer, and he says, I'm going to hold my offer open for 72 hours. 2 hours later, he withdraws his offer. He revokes his offer. He rescinds his offer. Don't lose sight of your English language. Withdraw, rescind, cancel, revoke, they all mean the same thing. Okay, the rule of contracts is you can always revoke, rescind, cancel, withdraw prior to acceptance. You can always do that, even if you've given a period of time. So he has withdrawn his offer. Does he get back his deposit?
Yes.
Yes. This happens, and what seemingly is some sort of ethical, moral dilemma is really not. Sometimes you can create facts that really sound very compelling, but this is actually something that does come up a lot. It's the elderly parent who's having trouble making ends meet in their house, and maybe not financially, but physically. And the kids are really tired of dealing with them, their elderly parent. And so they want mom to sell the house and move into some nursing home, some care facility where they don't have to come by all the time. So they want mom to sell the house in the worst way. So the real estate agent is hired. Now, who does the agent work for? Mom or the kids? Mom. An offer comes through, and it's really super crazy, ridiculously low. She's selling it, and the agent suggests you could get $300,000. Maybe word of mouth. The kids would let this house go for anything. So the offer comes in for $150,000. Does the agent have to submit the offer to mom?
Yes.
Right. Knowing that the kids would probably force mom into accepting the offer, still, must the agent still present the offer to mom?
Yes.
The answer is yes. You can't make that call. You have to present the offer. You've done nothing wrong by presenting the offer. As a matter of fact, if you don't present the offer, you've done something wrong. So you got to present the offer. Now, if the kids forced mom into it, that can possibly mean there is a defense that mom would have to void the contract, because it's a product of what? Undue influence and duress. So if the kids are making mom sign it, she's lacking that element of consent and can void the contract if she wants. But the agent still must present the offer. Doesn't mean the agent can't say, this is a shitty offer. I mean, you know, Mrs. Trumper, this offer is shitty, you know. Well, my mom would not let her kids force her into selling, you know. When she was alive, it'd be like, Mom, you know, the houses in this area are going for about $250. My house is worth $350. Why is that? Because I got really nice curtains. Okay, it's $100,000. They're very nice. You know my curtains. I'm like, yes, I do, Mom. But it ain't worth 200. You know, yeah, Mom was a little more like your typical seller, thinking things were worth way more than they are. You know, you guys in the back know exactly what I'm talking about. So, all right, so you got to present the offer. Okay. All right. Earnest money. Earnest money is the money that the buyer puts up at the time he's making his offer. Earnest money is not the consideration. So you've got a property, the purchase price is $100,000, the earnest money deposit is $1,000. Which is the consideration? The purchase price. The $100,000 is consideration. The earnest money is not consideration. It is just the money the buyer puts up at the time he's making the offer. All right. Okay. I live in California, and I buy some undeveloped property in Newcastle County, and I don't come out and visit it at all. At some point in time, someone drags a trailer out on the property, they drill a well, they put in an on-site septic, and they live there for over 20 years. Could I lose ownership of the property?
Yes.
Through what? What section? Adverse possession.
What part of the property?
The part I fence in, the part that I possess and maintain.
So, if that property part is separated, that parcel, it could be the entire parcel, even if it's occupied like 40 square yards.
Well, it really boils down to you have to adversely possess the parcel. That is, if you fenced in, let's say the property is 10 acres, and you fence in 2.5, and you don't do anything beyond those fence lines, then you've really just adversely possessed 2.5 acres. If you fenced in all 10 acres, and you put in a house that has a lawn, and the lawn is an acre, and you cut the lawn and maintain the lawn and have a house, the fact that you fenced in 10 acres, you can adversely possess the 10 acres. So, because the possession doesn't require you to do a whole lot other than exercise dominion and control over the property. And by putting a fence around 10 acres, you've done that. It's open, the fence is for everyone to see, it's hostile, it's against the owner's interest, it's continuous, you don't take the fence down every day, so you meet all those elements. Now, adverse possession can certainly boil down to facts. You haven't put a fence around the property, but you've cut the grass. But do you cut the grass in the wintertime? No. Is cutting the grass enough? Yeah. A lot of cases, maintaining the lawn around something that's not yours can rise to adverse possession. They sort of look at the continuous element of it is when things have to be done, you're doing it. Prescriptive easements, you know, we had a prescriptive easement case where we were arguing that the lifeguards who came and parked seasonally on the adjacent property owner's property, that can't give rise to prescriptive easement because the use isn't continuous. And then I did research, and seasonal use, 99 times out of 100, was deemed to be sufficient continuous use. So, you know, hopefully that helps you with your question there. Okay, condemnation is eminent domain. It's the process by which the government takes your property, a process called condemnation. So it's invoking the power of eminent domain to take private property for a public use for which the owner is to receive just compensation. So that's eminent domain. The government's power to take private property for a public use for which the owner is required to receive just compensation. That power is eminent domain. The process is called condemnation. Okay, elements of a deed. Number one, the statute of frauds requires the deed to be in writing. The other elements of a deed, and these can blur, I mean, they sort of overlap elements of an agreement of sale. So you need to be able to understand and distinguish the difference. So with a deed, the grantor has to be competent. The grantee does not. The grantor and the grantee have to be named in the deed. The deed has to have consideration. The next element is legal description. So, name of the grantor, name of the grantee. Grantor has to be competent, grantee does not. That's different than an agreement of sale. With an agreement of sale, both the grantor and grantee have to be competent. Only the grantor in a deed has to be competent. Okay. Legal description, consideration, and then the final elements. The deed has to be signed only by the grantor. Agreement of sale signed by the buyer and seller. The deed is only signed by the seller, the grantor. The grantor is the seller. Okay? The buyer does not sign the deed. He's named in the deed, but he doesn't sign the deed. Roger Granson conveys to Donna. Donna's the grantee. I'm signing the deed. Okay? I own the property. I'm the only one that can grant it, right? What would be the point of Donna signing a deed? She doesn't own it. She is the grantee. The grantor's signature has to be acknowledged. The deed has to have what's called an acknowledgement. So an acknowledged deed, a deed with an acknowledgement, is a deed that is notarized. So acknowledgement, acknowledged, means notarized. Okay? Now, no one's ever going to use the word notarized, not Dave and not me. We're going to use acknowledged as that element. It's not going to be the softball notarized, okay? So know that acknowledgement is something required of a deed. Do you have to notarize an agreement of sale?